Good afternoon. Our committee will come to order. And this afternoon we have a second part of our series of hearings on the implication of the Boumediene decision from the United States Supreme Court. For this afternoon's panel, we have Mr. Dell'Orto, who's the Acting General Counsel for the Department of Defense, Gregory Katsas, who is the Assistant Attorney General for the Civil Division of the Justice Department, Colonel Steve David, the Chief Defense Counsel in the Office of Military Commissions in the Department of Defense, and Sandra Hodgkinson, the Deputy Assistant Secretary for Detainee Affairs in the Department of Defense, who will not testify but will be available for questions. Am I correct? Okay. Ranking Member Duncan Hunter, remarks.
Hey, Mr. Chairman, let's get right with the program here, and I look forward to the witnesses' statements. I'm sure we'll have some good questions afterwards.
Thank you, Mr. Dell'Orto. You're on.
Thank you, Mr. Chairman, Ranking Member Hunter, and members of the committee for the opportunity to testify on the implications of the Supreme Court's Boumediene decision for detainees at Guantanamo Bay, Cuba. The Department of Defense is working diligently to satisfy the considerable litigation requirements stemming from the Supreme Court's decision in Boumediene v. Bush. The ramifications of that decision for the Department of Defense and for our nation are significant. The Department already has experienced some of these ramifications, while others are looming in the near future, and still others are as yet unknown. As significant as Boumediene is, it is only one in a recent line of decisions that establish an unprecedented level of judicial involvement in matters historically and, in the Department's view, most appropriately reserved to military professionals, including decisions on whom to detain as enemy combatants in an ongoing armed conflict. There are currently more than 250 petitions for the writ of habeas corpus pending in federal district court that involve more than 300 current or former Guantanamo detainees. Now that the Supreme Court has ruled that these petitions may proceed, the Department is diverting personnel and assets from other ongoing missions to respond to them. Those diverted are not just legal personnel and administrative assets. We also have diverted, or are in the process of diverting, substantial numbers of intelligence assets to support this litigation. The Department's immediate challenge is that what the law requires is currently unclear. As the Attorney General noted in a July 21, 2008 speech, the Supreme Court explicitly left many questions unanswered in Boumediene. The court said that Guantanamo detainees have a constitutional right to pursue habeas proceedings in federal court. The court did not say how these cases would proceed or what procedures and standards would apply. Given this lack of direction, and in the absence of legislation, the rules governing habeas proceedings for detainees at Guantanamo will be devised on an ad hoc basis in federal district courts. Although we do not know what the federal district courts will decree as the ultimate requirements for these proceedings, we anticipate a number of potential problems. First, these habeas proceedings could require the diversion of significant operational, law enforcement, and security resources in addition to administrative, legal, and intelligence resources. In addition to the significant resources the Department already is devoting to this litigation, if judges order the in-person appearance of detainees at hearings, numerous security assets would need to be devoted to the task. As alarming, if federal district court judges issue subpoenas requiring in-person testimony of those who gathered the relevant information pertaining to a habeas petitioner, combat troops, intelligence personnel, and other critical military and civilian personnel may need to be pulled from the theater of combat operations and sent to Washington, D.C. to answer questions from detainees' lawyers. As Justice Jackson presciently noted in Johnson versus Eisentrager in 1950, and I quote, "It would be difficult to devise more effective fettering of a field commander than to allow the very enemies he is ordered to reduce to submission to call him to account in his own civil courts and divert his efforts and attention from the military offensive abroad to the legal defensive at home." Indeed, the Supreme Court in Boumediene acknowledged that the conduct of habeas proceedings for Guantanamo detainees could raise national security issues. Second, the rules for habeas proceedings could affect how our soldiers, sailors, airmen, and Marines fight on battlefields around the world. It must be emphasized that petitioners in these cases have been detained under the law of war during an ongoing armed conflict. These are not the typical habeas proceedings in a civilian context with which the federal judiciary is familiar. Judges could require arrest reports, chain of custody authentication reports, or other evidentiary processes. Rulings that evidence must be excluded or that a detainee must be freed because certain evidentiary processes relevant to a civilian but not a wartime environment were not followed would in effect serve to regulate our troops on the battlefield, just as judges in effect regulate the local police in civilian life. Third, habeas proceedings could be used as a vehicle for detainees charged with war crimes to attempt to halt or delay their military commission trials. The Supreme Court ruling in Boumediene was focused on challenges to the lawfulness of detention, not on military commission procedures as provided in the Military Commissions Act. Further, the court looked favorably on the adversarial proceedings of prior military commissions. Although a federal district court judge recently rejected the effort of one detainee to block his military commission trial, another detainee already has filed a court challenge to stop his military commission from moving forward, and others almost certainly will follow. As the Attorney General explained, Americans charged with crimes in our courts must wait until after their trials and appeals are finished before they can seek habeas relief. So should alien enemy combatants. Finally, the Supreme Court, while providing access for detainees to the federal district courts for habeas proceedings, let stand the alternative route to the Court of Appeals for the District of Columbia Circuit Court under the Detainee Treatment Act. Detainees now have two separate and redundant legal channels through which they can challenge the legality of their detention, one under the Detainee Treatment Act and the other under the Constitution. This dual-track challenge to detention only serves to strain the resources of the Department further, providing detainees greater opportunities to challenge their detention than those that are available to U.S. citizens imprisoned in the United States. These are but a few of the concerns we have about Guantanamo detainee habeas proceedings and their consequences for the Department. We recognize that there are opposing considerations and that writing the rules governing these habeas proceedings will require a difficult balancing of interests. The Department acknowledges and respects the judgment and expertise of the federal courts. Nevertheless, Congress is best suited to conduct this balancing and to write the rules for habeas proceedings for detainees at Guantanamo Bay. The federal district courts do not have the institutional competency that Congress has to address these questions effectively and efficiently, appropriately taking into account national security concerns and the potential impact on ongoing military operations. Further, judges might impose conflicting rules, putting the Department in an untenable position at least until those differences can be resolved in higher courts after considerable delay and uncertainty while the war on terror continues. Although the D.C. District Court is attempting to coordinate the cases to some degree, many substantive issues likely will be determined by multiple judges in individual cases. Finally, unlike Congress, federal judges cannot consider and refine the entire statutory framework of Guantanamo detainee legal process. By providing rules for habeas proceedings, Congress can ensure that habeas proceedings do not delay trials by military commission and justice for the victims of the September 11, 2001 attacks. Congress can ensure that the government does not waste resources litigating and relitigating the very same issues in the more than 250 pending habeas petitions and in the more than 190 cases in the United States Court of Appeals for the District of Columbia Circuit under the Detainee Treatment Act. Legislation, not litigation, is the best vehicle for writing these rules. The Department of Defense fully supports the 6 specific principles that the Attorney General suggested should guide the legislation of rules for habeas proceedings for detainees at Guantanamo Bay, Cuba, as he articulated in his recent speech. First, Congress should make clear that federal courts may not order the government to bring, admit, or release those detained at Guantanamo Bay into the United States. Second, Congress should ensure national security secrets are protected and that terrorists do not use these proceedings as a means to discover what we know about them and how we acquired that information. Third, Congress should make clear that habeas proceedings should not delay the military commission trials of detainees charged with war crimes. Fourth, Congress should explicitly reaffirm that the United States remains engaged in an armed conflict with al-Qaeda, the Taliban, and associated organizations, and that the United States may detain as enemy combatants those who have engaged in hostilities or purposefully supported al-Qaeda, the Taliban, and associated organizations. Fifth, Congress should establish sensible procedures adapted to the realities of national security. To eliminate duplicative efforts and inconsistent rulings, one district court should have exclusive jurisdiction over these habeas cases, and common legal issues should be decided by one judge in a coordinated fashion. Military service members should not be required by subpoenas to leave the front lines to testify as witnesses in habeas hearings. Affidavits prepared after battlefield activities have ceased should suffice. Military members should not be required to create such documents as the arrest reports and chain of custody logs that civilian law enforcement entities use. Sixth, Congress should make clear that the detainees cannot pursue other forms of litigation to challenge their detention. Congress should eliminate statutory judicial review under the Detainee Treatment Act. Congress should reaffirm its previous decision to eliminate other burdensome litigation not required by the Constitution, such as challenges to conditions of confinement or transfers out of U.S. custody. Along these lines, the Department of Defense requests that legislation expressly confirm that the habeas jurisdiction of the federal courts does not extend beyond the holding of Boumediene. We believe this proposition is reflected in the current law following Boumediene, which extended constitutional habeas jurisdiction based on the unique circumstances prevailing at Guantanamo Bay. It goes without saying, however, that all of the difficulties that we face with respect to the Guantanamo habeas petitions would pale in comparison to the difficulties we would encounter were federal court jurisdiction extended to those detained in or near a zone of active hostilities, such as in Iraq and Afghanistan. The burden of litigating the petitions of some 270 detainees at Guantanamo is considerable, but the prospect of litigating the petitions of multiple hundreds of alien detainees in Afghanistan and tens of thousands of alien detainees in Iraq would simply be crippling. The Constitution of the United States hardly contemplates such a result. In conclusion, although the topic of today's hearing is the implications of the Supreme Court's Boumediene decision for detainees at Guantanamo Bay, Cuba, I have begun by discussing the implications of Boumediene for the Department of Defense. In my current position as Acting General Counsel of the Department of Defense, as in my previous career as a judge advocate and Army line officer for more than 27 years, my foremost duty has always been to our troops, to ensure that they can lawfully do what is necessary to fight and win our nation's wars and to defend our nation from attacks, whether those attacks come from adversary nations or from non-state actors such as al-Qaeda. We must remain mindful that the enemy we face today and have faced since the early 1990s uses 21st century technology to perpetrate brutal, indiscriminate attacks on civilians. As the Congress considers legislation in response to Boumediene and weighs the many important interests at stake, I respectfully trust that you will carefully consider this as well. Thank you very much.
Mr. Katsas, Assistant Attorney General.
Thank you, Mr. Chairman.
Get as close to that as you can, would you please?
Can you hear me? Mr. Chairman, Congressman Hunter, members of the committee, you have my full written statement, so let me just give you a brief summary here. I appear before you today as the Assistant Attorney General for the Civil Division, which is responsible for handling the hundreds of habeas corpus and Detainee Treatment Act cases brought by aliens detained as enemy combatants at Guantanamo Bay, Cuba. In the wake of the Supreme Court's Boumediene decision, the parties to those cases and the lower courts face unprecedented challenges. Boumediene makes clear that its extension of habeas corpus to review wartime status determinations of aliens captured and held outside the United States is unprecedented. In this context, there are no controlling federal rules or statutes. There are few relevant federal precedents. There is no past experience, And while Boumediene itself recognized that habeas proceedings in this context must take account of practical considerations and wartime exigencies, the court gave little guidance about how to proceed with the enormously difficult and sensitive task of ensuring fairness to detainees while at the same time not unduly impeding the prosecution of an ongoing armed conflict. Recently, the Attorney General invited Congress to establish some guidelines for the efficient, fair, and safe adjudication of these difficult habeas cases. Let me briefly give you a litigator's perspective on the urgency of his 6 specific proposals. First, judges should be prohibited from ordering the release of detainees into the United States. In one case, we already have a pending motion for release not only into the United States, but into Greater Washington, D.C., and even before habeas proceedings have run their course. Congress should act quickly to prevent judges from releasing potentially dangerous individuals into our midst. Second, habeas procedures should ensure adequate protection for classified information. The military must never be put to an impossible choice, as our opponents have urged, between revealing classified information to al-Qaeda or releasing dangerous al-Qaeda operatives. Third, habeas proceedings should not interfere with war crimes prosecutions before military commissions. In Boumediene, the Supreme Court cited adversarial military commission procedures with approval. Yet in the habeas litigation, Ramzi bin al-Shibh, who prosecutors believe was a principal facilitator of the September 11 attacks, has moved to stop his war crimes trial through habeas. Congress should act to ensure that the trials move forward so that terrorists can be brought to justice. Fourth, Congress should reaffirm the President's detention authority in the ongoing armed conflict with al-Qaeda. We think that authority is obvious, but in the recent El Mari case, 4 of 9 judges on the Fourth Circuit would have held that the military lacks any authority to detain any member of al-Qaeda, not Khalid Sheikh Mohammed, not Mohammed Atta if we had managed to catch him in time, not even Osama bin Laden. Congress should definitively correct that dangerous misunderstanding of military authority. Fifth, Congress should establish sensible procedures to govern the adjudication of the pending habeas cases. The question of what procedures are appropriate remains entirely unsettled. The judges have asked for briefing on basic procedural framework issues, such as burdens of proof, extent of discovery, and the need for evidentiary hearings. In no other context that I know of are fundamental rules like that so basically unsettled. To facilitate the prompt and uniform handling of these cases, Congress should adopt a streamlined but fair framework along the lines that the Supreme Court approved for habeas proceedings involving citizens held as enemy combatants. Sixth and finally, Congress should eliminate the now unnecessary judicial review proceedings in the Detainee Treatment Act, which were intended as a substitute, not as an addition to habeas. Now that habeas review is once again available, there is no sense in requiring the government, the detainees, or the courts to engage in the duplicative adjudication of about 190 Detainee Treatment Act petitions on top of about 250 pending habeas petitions. Thank you very much.
Colonel David? Please get a little closer. Turn it on.
Thank you again, Chairman
There you go.
Skelton, members of the House Armed Services Committee. My name is Colonel Steve David, and I am grateful for the invitation and honored to testify before this committee. I have prepared and submitted my testimony, so what I intend to do is summarize that testimony and then give you all more time to ask questions. My testimony is given in my capacity as a private citizen who is currently serving as the Chief Defense Counsel in the Department of Defense Office of Military Commissions. My testimony does not represent the opinions of the Department of Defense, the Army, my subordinates, or any other entity. I've been asked to testify today about the implications of the Supreme Court's decision in the Boumediene case and how they are likely to affect the detainees at Guantanamo Bay. I've served as the Chief Defense Counsel in the Office of Military Commissions since August of 2007. I have, in that time, seen the number of cases expand from 2 to 21. I've served the United States Army for over 26 years in a myriad of assignments, both on active duty and as a member of the Reserve Component Services. While I'm currently serving as Chief Defense Counsel, I'm on leave from my civilian profession as an elected trial court judge in the state of Indiana. I've served over 13 years as a trial judge in Indiana. I consider myself a public servant. I've also served as a military judge, both in the Army Reserves and on active duty in the United States Army. I'm proud to be an elected office holder, and I'm proud to wear the uniform of the United States military. In my office in Boone County, Indiana, I proudly display with great reverence the flag of honor with the names of the 9/11 victims. I do not see my role as Chief Defense Counsel or my obligations as an officer of the United States military or as a judge in any way inconsistent with these obligations. I think they are entirely consistent. Because of the unique vantage point I have, I will generally confine what I have to say to what Boumediene means for the military commissions. To put it briefly, the most important thing that Boumediene held is something that I always thought was obvious. Like Thomas Paine in Common Sense, in America, the law is king, for as in absolute governments, the king is the law. So in free countries, the law ought to be the king, and there ought to be no other. Boumediene held that in America, there are no law-free zones. This is an issue only because the choice in 2002 to move enemy combatants from Afghanistan and terrorism suspects captured around the world to U.S. military base at Guantanamo Bay. Even though the government treats the base as if it were U.S. soil for every other purpose, it has taken the position that it is foreign soil when it comes to the constitutional rights of the people we hold there. Boumediene puts that convenient theory to rest. In particular, Boumediene makes it clear that federal courts will ultimately have habeas review over the military commission's process, and the commission defendants have constitutional rights. The gist of the court's holding is that unless enforcing a right would be impractical, it should be honored. If the suspension clause applies in Guantanamo, then so must the ex post facto clause and other fundamental due process rights, like the prohibition on the use of coerced statements and the right to confront one's accusers. There is nothing impractical about ensuring that the commissions live up to basic American standards of justice. The constitutional protections promised by Boumediene are particularly important at a time when the highly politicized atmosphere surrounding the commission trials has begun to compromise their fairness. The legal advisor at the Community Authority has been disqualified from one case already for overstepping the role to such an extent that it amounted to unlawful command influence. Much of this appeared motivated by a desire to accelerate as many of the cases as possible before the presidential election. If this process cannot survive a presidential election, I submit to you it cannot survive and does not deserve to survive. Which brings me to the question of whether, after Boumediene, these commissions should survive. To reiterate my opening point, Boumediene reaffirmed what should be a surprise to no American, that where our government is sovereign, the Constitution is sovereign. The fact will lead to the ultimate striking down of the most constitutionally suspect of the military commission's procedures now in place. The only question that remains is how long it will take, how many convictions must be reversed, and whether it will be the product of the rulings of the military judges presiding over the commissions or the federal courts on appellate or habeas review. Since it is now simply a question of when, the only remaining one is why we started down this road in the first place. The ultimate tragedy is the United States federal courts and military courts martial are more than capable of trying terrorists under traditional principles of American justice. As one of my favorite country music singers, Toby Keith, explains in one of his songs, there ain't no right way to do the wrong thing. It would have been better had we done the right thing from the beginning, but it's not too late to change direction and do it now. I advocate that we utilize the federal criminal court system with the safeguards in place, or the military justice system on a uniform code of military justice. Thank you for the opportunity to address your group. Again, I've submitted my testimony in written format and be happy to answer any questions.
Thank you very much. We have a series of 6 votes, one 15-minute vote and the other is 5 minutes. It'll probably be about a 40-minute break, and I hope that doesn't disturb your afternoon too much, but I think we could, might be wise just to go ahead and it's a good place to break and come back as soon as we can. We'll resume the questioning. But thank you again for being with us. We look forward to questions shortly. We'll take recess.